How can people be advised if they plan to plead guilty for DUI? Attorney Mace Yampolsky explains that. I tell my clients that under the law, it does not matter what they actually did. What matters is what the state could prove. Let us suppose the client told me they were drunk. They went around the corner and hit a parking meter and then walked home. Because they were drunk, they felt they should just plead guilty. The police saw the vehicle and then either saw the client when he was at home or they saw him when he was walking across the side of the road. But they never saw him behind the wheel. The question would be whether he was under the influence when he was behind the wheel, or whether he had been drinking at home, because they would just not know. If we ever have this defense, then we need to plead it specifically, meaning we need to tell the prosecutor that we wanted to rely on drinking after he stopped driving as a defense. The other scenario would be if the police saw him walking down the road and he was about a half a mile or a mile away. The police would not be able to prove when he was actually driving, so they would not be able to prove beyond a reasonable doubt whether or not his blood alcohol level was over a 0.08 at the time he was driving. Since he had had an accident, one could assume that he was under the influence of alcohol to any degree, however slight, which made him incapable of driving safely. But could you prove it? We could defend that by saying that although he had had an accident, hundreds of thousands of people have accidents every single day when they are stone cold sober. I actually handled a case just like that, and it was a third-time DUI. We were able to resolve it as a felony reckless driving, so there was no mandatory prison time. For a free phone consultation, contact attorney Mace Yampolsky in Las Vegas, Nevada at 702-843-0939 or visit his website at www.macelaw.com.